Hello friends, my name is JJ, and today we are going to do something that we do not often do on this channel, which is discuss a current event. On January 5th, 2024, the Supreme Court of the United States agreed to hear an appeal from Republican presidential candidate Donald J. Trump, who had recently been stricken from the ballot in the state of Colorado. That state's highest court had ruled that Trump was not constitutionally eligible to serve a second term as president, according to the rules of the 14th Amendment. Now, this theory that Trump should not be legally permitted to run for a second term is an argument that has been growing in popularity in recent months and provoking considerable debate in the process. And with their recent announcement, the US Supreme Court will now officially settle that debate, likely sometime next month. I find the whole situation very interesting because the question of whether Trump is legally eligible to run for a second term is a complicated one that does not have an easy answer for honest people on either side of the political divide. The 14th Amendment is written in a sort of peculiar way, and in choosing to uphold it or not uphold it, we are forced to make trade-offs between values like democracy versus law or due process versus safety. On the one hand, there are those who find it deeply distasteful that Trump could just be straight up banned from running for president. And they feel this regardless of what they think about Trump as a politician himself. The idea of banning a candidate feels very undemocratic and against the American political tradition, which is, of course, letting the voters decide. But then, on the other hand, it is also part of the American tradition that no one is above the law, and the Constitution is something sacred and has to be enforced independently of how doing so makes anybody feel. To ignore the text of the Constitution just because it might bother some people is to commit an offense against a larger American democratic system. As we shall discuss, if Trump is disqualified, he will be disqualified for very specific things that he did, things that a lot of Americans view as very serious crimes against that same democratic system. And this then invites debate about whether American democracy should be open to everyone or closed off to certain bad actors for the greater good of the country. But on the other hand, maybe this is all just a big misunderstanding. Maybe Trump isn't actually disqualified by the 14th Amendment at all, and the whole situation can be calmly resolved in a way that both upholds the letter of the law and the ability of American democracy to operate in its usual fashion. This is what the Supreme Court has to decide, and today I thought it might be worth discussing the many ways to analyze this most complicated of cases, a case which is almost certainly destined to culminate in one of the most important rulings in American history. So, the argument that Trump is legally ineligible to be president again is based on an interpretation of Section 3 of the 14th Amendment to the United States Constitution, which was ratified in 1868. And it reads, in full, "No person shall be a senator or representative in Congress, or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability." Now, I'm no fancy big city lawyer, but I have been listening to an awful lot of podcasts in which lawyers argue about how to understand this tricky part of the Constitution and whether it does or doesn't apply to Donald Trump. In particular, I have paid a lot of attention to the legal analysis of the following four men: Lawrence Tribe, who is a Harvard professor of constitutional law and widely regarded as one of the most important constitutional scholars in modern American history; Benjamin Wittes, who is a longtime legal analyst in the media and currently editor-in-chief of Lawfare, a leading online journal of American legal analysis; David French, a popular political commentator who previously served as senior legal counsel for the conservative activist group, the American Center for Law and Justice, which focuses on constitutional law, and Senator Ted Cruz, who, despite his obviously contentious public persona, has a very partisan Republican politician, is also probably the most accomplished lawyer in the US Senate, having worked at the Supreme Court as a young man and argued many cases before them in his former job as Solicitor General of Texas. All of these guys have been following the Trump disqualification case very closely and have offered up a lot of argument about why they think it will or won't stick. Basically, the first three think the case for disqualifying Trump is strong, but are unsure if the Supreme Court will agree, while Senator Cruz thinks the case for disqualifying Trump is weak, but also thinks that the Supreme Court will likely only let him run on very narrow and technical grounds. And based on my analysis of their analysis, the key questions that the Supreme Court has to answer in this case come down to the following. Does the 14th Amendment apply to former presidents? Did Trump do something bad on or around January 6, 2021? If so, how should we characterize that bad thing? Does Trump need to be convicted of something? And is the 14th Amendment self-executing? Questions the Supreme Court is not supposed to consider, incidentally, include how their ruling will make people feel or what the political fallout will be. This is particularly worth noting given that the current US Supreme Court is characterized as being quite conservative, not necessarily in a partisan political sense as much as a dispositional analytic sense. Which is to say, they have a reputation, partially self-proclaimed, for being judges who take the words and intent of the Constitution very seriously, and often literally, and are not inclined to be influenced by things like social trends or the current political atmosphere. So, let's get to the questions. Question 1. Does the 14th Amendment apply to former presidents? So, Trump's lawyers have made every possible argument that the 14th Amendment doesn't apply to their client, which is what you would expect good lawyers to do. And one of their most dramatic claims is that the 14th Amendment can't be used against former presidents at all, though this is also pretty universally taken to be their weakest argument. If we look at the text of the 14th Amendment, we can see that it talks about disqualifying former senators, representatives, presidential electors, and other miscellaneous officers of the United States who have previously taken an oath to support the Constitution of the United States. And the argument is that since former presidents aren't specifically mentioned, basically the whole conversation about disqualification stops right here. The rebuttal is just that it requires some pretty creative legal logic to argue that a former president is not an officer of the United States who has previously taken an oath to support the Constitution.
Constitution of the United States.
Likewise, it would be kind of inexplicable for the amendment to disqualify people from serving as presidential electors, but not president proper. Not mentioning presidents directly is likely just a relic of the fact that in the 19th century, presidents were never spoken of as being directly elected, with any effort to regulate the election of a president always taking the form of regulating the election of presidential electors in the Electoral College, which is obviously not how anyone talks about these sorts of things today. In any case, like I said, this is not considered a particularly strong argument, and even Trump supporters do not dwell on it too much.
I would be surprised if that persuades the court.
The clear intent of the 14th Amendment is to issue a sweeping ban preventing a certain sort of former politician from ever again holding any important office in the US government. And what certain sort of person did they have in mind? Well, that brings us to the second question. Question 2. Did Trump do something bad on or around January 6, 2021? If so, how should we characterize that bad thing? Now, this is the big one. The 14th Amendment says that anyone who engaged in insurrection or rebellion against the Constitution or has given aid or comfort to the enemies thereof is disqualified from office. And is that what Trump did on or around January 6, 2021? Some legal analysts say the answer is pretty self-evident. Using our own eyes and ears and observing the enormous amount of reporting that exists documenting that particular period of time, it is pretty clear that Trump did not accept the fact that he lost the 2020 election and actively plotted to prevent Joe Biden from assuming office.
We were getting ready to win this election. Frankly, we did win this election.
We found massive fraud, and in other states also.
This is probably the most fraudulent election that anyone's ever seen. We will never concede. It doesn't happen. You don't concede when there's theft involved.
Professor Tribe sees Trump's actions as a specific conspiracy against the Constitution's Article 2, which describes how presidential elections are ratified by Congress. And this is what Trump specifically sought to prevent from happening through his pressure on Vice President Mike Pence, the chair of the Senate, his involvement in the so-called fake elector plots, and his encouragement of a mob that tried to physically prevent the Congress from ratifying his election loss.
From the very moment of the election, there is evidence, very strong evidence, that Donald Trump said, "I'm not leaving. I don't care who says I lost. I don't admit that I lost. I think the election was stolen." And he was willing to do whatever it took. The evidence over the past week in Colorado was very strong that he was directly involved in the fake electoral slates. And in addition to that, that he in fact did rile up the mob and very occasionally said, "Oh, be peaceful." But on the other hand, he did everything he could to make sure they wouldn't be peaceful.
Now, the big Trump defense, as far as this goes, just consists of saying that his conduct on and around January 6th wasn't really that bad and certainly doesn't rise to the level of an insurrection against the Constitution. Trump simply had questions about the integrity of the 2020 vote and wanted to see the results disputed through the congressional procedures that the Constitution itself allows. And of course, given the fact that Trump is not president anymore, it is clear that he did ultimately accept the results of the 2020 election once he ran out of options to contest it. And to the extent he was involved in the January 6th mob, it was the very limited involvement of giving a single vague speech that contained little in the way of specific instruction or incitement.
Donald Trump sent some tweets and stood up and gave a speech in which he told people,
to
be
go
peaceable.
Yeah, go peacefully.
Be peaceful.
We have come to demand that Congress do the right thing and only count the electors who have been lawfully slated. Lawfully slated. I know that everyone here will soon be marching over to the Capitol building to peacefully and patriotically make your voices heard. Today we will see whether Republicans stand strong for integrity.
Trump likewise didn't participate in any of the January 6th violence himself, even if he was broadly sympathetic to it and has mostly defended the January 6th rioters since leaving.
The whole thing is just very unfair. But those J6 hostages going to jail for 20 years and 18 years and 12, doctors, lawyers, carpenters, electricians, truck drivers. It's one of the saddest things. It'll go down as one of the saddest things in the history of our country. And they went there to protest a rigged election. And now when the facts are in, they see it is a rigged election.
But the point is, people do disagree about whether what Trump did was bad and whether the badness of what he did rises to the level of an insurrection, rebellion, or plot to give aid and comfort to enemies of the Constitution. Which brings us to the third question. Does Trump need to be convicted of something? So this is basically a debate over the intent of the 14th Amendment and how harsh or unforgiving it's supposed to be. In a recent podcast appearance, David French argued that Amendment 14 is basically an ideological screening test that was created in the aftermath of the United States Civil War, and its intent was to aggressively and automatically disqualify from office any former politician who had previously engaged in anti-constitutional behavior, including former members of the breakaway Confederate government, but others as well. The amendment was written in a very zealously righteous time in American political history, and was not intended to be a particularly generous part of the Constitution. It was specifically supposed to apply to a ton of ex-politicians and keep them out of American politics forever. It was by design intended to harshly punish people for engaging in behavior that in a pre-14th Amendment world might have been considered free speech or legitimate political activism. This is anti-democratic in a broad sense, but French says it is important to remember that there are lots of anti-democratic things in the US Constitution, and for good reason.
We have a lot of counter-majoritarian
guidelines that limit the reach and scope of our democracy. So that's the way liberal democracy is. Liberal democracy, a good way of thinking about it, is democracy with guardrails. And some of the guardrails are deliberately designed to prevent majoritarian oppression and tyranny. So a majority can't vote away your First Amendment rights. A majority can't vote away your rights to equal protection under the law or your due process rights. So all of these things guard and protect people against majoritarian tyranny. And so here what you have is a counter-majoritarian provision of the Constitution enacted quite deliberately because the framers of the amendment, the authors of the amendment, believed and had seen that majorities can elect insurrectionists, and insurrectionists can be fatal to a constitutional republic.
As such, getting a politician disqualified for having engaged in insurrection or rebellion is a procedurally simple matter of just getting a court to find evidence that the candidate engaged in this sort of behavior, like the Colorado Supreme Court did. Now, Senator Cruz does not dispute that the Constitution intends for insurrectionists to be disqualified, but he thinks that there has to be some sort of criminal conviction first. He notes that rebellion or insurrection is an actual crime in the U.S. Code.
So here's what 18 U.S.C. Section 2383 says. It's entitled Rebellion or Insurrection. Whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years, or both, and shall be incapable of holding any office under the United States.
As you can tell from the language, that statute is very clearly based on the 14th Amendment, but Trump has never been found guilty of breaking it. He hasn't even been indicted for breaking it. Only once Trump is found guilty of the crime of insurrection or rebellion can a court pull Trump off the ballot, says Cruz. This is a pretty intuitive argument because it emphasizes the common sense understanding that insurrection or rebellion is a relatively subjective allegation as opposed to some of the other things that the Constitution disqualifies politicians for, like being too young, which can be easily and objectively proven. And so people like Cruz argue that the easiest way to resolve the subjectivity of this allegation is through a criminal trial. But a lot of the other legal analysts disagree strongly with this interpretation, saying that if the amendment wanted to ban candidates who had been convicted of insurrection, it would have said so explicitly. Likewise, just because the Constitution sounds like it's talking about a crime doesn't mean that thing should be literally understood as referring to a crime in the formal legal sense. Benjamin Wittes says that the 14th Amendment should instead be understood as treating participation in an insurrection against the Constitution as a fact-finding matter. He thinks the courts should be involved, but in a distinct way from what Cruz wants.
What's being litigated in Colorado is a factual question, which is, did he engage in insurrection? And among other things, there are some other issues. But and so it wouldn't be, there would be a judicial finding. It would be the judicial finding, roughly, equivalent to Charlie Sykes, you're running for president. Yeah. But I have here your birth certificate and you're 34. You don't need to be convicted of being 34, right? You just need to be not qualified to be president. And so I think there would, the question of whether you would need to resolve that as a criminal matter is one of the arguments that, I have not been convicted of engaging in insurrection. Right. But the counter argument is the language doesn't say anybody who was convicted of insurrection. Right. The language says anybody who engaged in it, right? Who took part in it. And so that's just a factual question. Well, courts resolve factual questions all the time.
A constitutional analogy I would make would be impeachment. The Constitution says that presidents can be impeached for committing high crimes and misdemeanors, yet it is generally understood that this doesn't mean literal crimes and misdemeanors as defined by the criminal code, but rather crimes and misdemeanors in a broad political cultural sense as determined by a vote of the Congress. And by this logic, so too is the degree that a former politician engaged in insurrection and rebellion judged using a different standard than criminal responsibility.
The question in the Constitution is, did you do it? And it doesn't, by the way, spell out how you figure out the answer to that question. But the question is not a question that sounds in criminal law. It's a question that sounds in objective reality. And I think the objective reality is that Donald Trump did something that seems awfully like lead an insurrection.
And this brings us to the final question, which is actually kind of similar. Is the 14th Amendment self-executing? Self-executing is basically just a fancy way of saying, is the text of the Constitution able to function on its own, as opposed to only being able to function after Congress passes specific laws to make it function. A good example would be what we discussed last week, which is the part of the Constitution that says that copyrights can exist. That part of the Constitution is vague and aspirational, and is preceded by the words, "the Congress shall." So clearly, the copyright provision of the Constitution is not self-executing. It needs help from the Congress to make it work. And Senator Cruz would argue that the 14th Amendment is similarly way too vague to work without Congress's help, as he describes here, quoting from one of the dissenting judges from the Colorado case.
Justice Samore concluded that Section 3 is not self-executing and requires legislation for enforcement. And he argued that the lower court's proceeding in Colorado lacked basic discovery, lacked the ability to subpoena documents, lacked the ability to compel witnesses, lacked any time frame to investigate or develop defenses, and lacked the opportunity for a fair trial. And he pointed out that, in his view, Section 3 cannot be self-executing because it doesn't provide any procedural guidance. For example, Section 3 of the 14th Amendment is completely silent on whether a jury has to be impaneled or not. Can a judge decide it? Or does it have to be a jury of your peers? Well, Section 3 doesn't say it. What's the burden of proof? Is it beyond a reasonable doubt? Is it clear and convincing evidence? Is it simply a preponderance of the evidence? Those are very different burdens of proof. Constitution is silence on that. What's the standard of review? What's the standard of discovery? What's the standard of evidence? Is it a civil determination or a criminal determination? None of that is there. And so what he argues is that Congress could pass legislation to adjudicate that. I'm not entirely persuaded on that. What I would say is Congress has passed legislation when it set up a criminal statute for insurrection, that there is a mechanism and it is a criminal trial.
And charge him.
But others say no. When you look at the historic context, the amendment was explicitly set up to be self-actualizing precisely because the authors of that amendment, the victors in the U.S. Civil War, had little faith in the American criminal justice system or the American political system, as Professor Tribe describes here.
One of the reasons that the 14th Amendment included this special protection against insurrectionists and rebels against the Constitution was the thought that the criminal process might not work, that in fact the federal government might be in the hands of the insurrectionists, as in fact happened after Lincoln's assassination, when Andrew Johnson, who was very sympathetic with the Confederacy, became president. He made it clear that he would not prosecute people who tried to overturn the Constitution on behalf of the Confederacy, and that he would in fact pardon anyone who was convicted. So this has got nothing to do with whether Donald Trump will or will not go to jail.
Another argument would be that you can prove the amendment is intended to be self-executing by looking at its final sentence, where it says, Congress may, by a vote of 2/3 of each house, remove such disability. The fact that there is only a clearly described way to undo a disqualification can be seen as implying that the authors of the amendment intended the disqualification itself to be automatic. Again, it suggests that the priority was the mass-scale disqualification of a lot of people with requalification something that would only be done in exceptional circumstances. Now, as we said earlier, it is easy to argue that this whole idea of disqualifying a presidential candidate via a single fact-finding court ruling is fairly undemocratic. But for men like David French, who advocate for a strict, literal reading of the Constitution, sometimes that's just how it goes.
It's very valid to say, should this have been written this way? Isn't it preferable to say that there should have been a criminal conviction? Isn't it preferable for the amendment to have laid out a precise process? Or maybe even a better way of putting it, isn't it preferable, Ezra, that Congress would have already acted under the power given to it by the 14th Amendment to specify a process? I think those are all very valid questions, policy questions. This is a broadly worded section of the amendment, for better and for worse. And some of the implications can get a little alarming, but there are remedies for that. And the remedies include, well, get Congress to act to specify a process. That's one remedy. Another remedy would be to amend the section of the Constitution. But as of right now, this is the section.
And I think this offers a good segue into some concluding thoughts I have about how I figure all of this stuff is going to play out in practice. A lot of the legal analysts who have argued for Trump to be disqualified are quite philosophically conservative. The organization that started this whole legal case in Colorado was led by a group of Republican voters, and perhaps the most influential essay written in favor of Trump's disqualification under the 14th Amendment, a piece titled "The Sweep and Force of Section 3", was written by two very conservative legal scholars known for their adherence to originalism, or the idea that the Constitution should be read as literally as possible. Many liberals eager to see Trump go down have been delighted by the unexpected presence of these conservative intellectuals on their side. But it's worth remembering that in most other circumstances, liberals don't really consider super dogmatic conservative legal arguments to be terribly logical or persuasive. And this matters because despite the conservatism of the current US Supreme Court, it does not go without saying that those judges are quite as dogmatic in their understanding of how the Constitution works as some of the conservative commentators making the case for Trump's disqualification. Of the four men I've been quoting today, only Ted Cruz is convinced that his arguments will actually win over the court. Senator Cruz thinks it's pretty likely that the Supreme Court will even rule unanimously in Trump's favor, but strictly on the conviction question, which is to say they will agree that you do, in fact, need to have been convicted of the crime of insurrection or rebellion in order to be disqualified from office under Amendment 14. He thinks they won't even bother to judge Trump's January 6th conduct one way or another because it's irrelevant to what are basically going to be just due process considerations.
I'm willing to bet right now there will be a sentence in the opinion that says, "We express no opinion on whether or not an insurrection occurred on January 6th.
So they're gonna say that's not what we're here to do. That's not what we're deciding. We're not part of that debate.
Right. I think what they will say instead is, however, the determination of that matter cannot be made without evidence, without due process, without a judicial proceeding.
The other guys, by contrast, don't seem to have a lot of faith in the persuasive power of their arguments.
Neither Judge Ludig nor I pretends to predict what a court with 3 Trump appointees and some other very, very conservative members who are conservative, in my view, in name only. They're really quite radical. We're not predicting what they will do.
At a gut instinct level, it's kind of hard for me to see the Supreme Court doing something this dramatic.
So I do think it's a pretty heavy lift at the Supreme Court.
And that's in large part because they are all willing to concede at some level that Supreme Court rulings are not, in fact, just about the law, but also how the law integrates with American values and impacts American society. The judges will certainly consider things like the 14th Amendment's original intent and exact wording, but they'll also apply their own personal biases in the sense of what they think the law should aim to do and what they think is in the best interests of the country. And again, knowing the conservative style of this particular group of judges, I think the smart money is that they will err on the side of upholding the most minimally disruptive interpretation of the 14th, which is the one that allows Trump to stay on the ballot. And while I get the thought process that leads there, I am not personally convinced that that is the correct conclusion, either as a matter of law or a read of America's current political climate. I particularly hope that fear of the imagined destructive political fallout that would result from disqualifying Donald Trump plays no role at all in how the Supreme Court rules. I understand that a lot of people live in fear of Trump supporters these days, but it's worth remembering that the only reason the court is even hearing this case in the first place is because Donald Trump stirs up political chaos regardless of how fair or democratic his treatment is.